to Kumasi, where there was near chaos at the Kumasi High Court when lawyers for the Kwame Nkrumah University of Science and Technology refused to be served a stay of execution filed by Clement Ohene Asare at the court premises. Ohene Asare, who claims to be alumnus of the KNUST, filed an injunction to thwart the reappointment of the Vice-Chancellor, Professor Rita Akosua-Dixon, but the court dismissed his request. Shortly after the verdict, the applicant appealed the High Court's decision, but lawyers for the university opposed being served within the precincts of the court. Emmanuel Bright Kweku was in court and has come through with this report.
During proceedings at the Kumasi High Court, counsel for the applicants argued the reappointment of the Vice-Chancellor was procedurally wrong per the statutes of the university in extending the tenure of office. He cited a breach of the procedure for the appointment, wherein a 7-member search committee is constituted to propose an ideal candidate for consideration and the advertisement of the vacancy of the Vice-Chancellor position for the application of other viable candidates. But this was opposed by counsel for the defendants, the university and Vice-Chancellor, insisting they complied with the reappointment statutes. Presiding Judge Justice Frederick Tete dismissed the application, describing it as one that lacked merit and capacity. He further questioned the status of the applicants who had indicated in his application to be an alumnus of the university. Mr. Ohene Asare failed to convince the court of being an alumnus of the university.
Now in court, there was nowhere in the processes that defense counsel said that they have not breached the statutes and the acts of the university. However, they decided to waste time on capacity and locus. The court said that I am not a registered member of the alumni. When an issue borders on illegality, whoever is bringing the matter to court is immaterial. We are filing a stay of execution just today, and I believe that we will have to wait till a better judgment.
Shortly after the court dismissed the injunction, the plaintiff filed an appeal, and this created a near confusion at the court premises when the bailiff attempted to serve the lawyers of the university. The lawyers had argued that they needed to be officially served at the university and not the court premises.
He was in court and announced himself as representing the school.
But is it the school? Go to the school and go and serve. You know service. Who do you serve? Who do you serve?
You guys, if he doesn't want to take it, drop it to him and leave.
Go to the school and go and serve your man.
University Relations Officer Dr. Daniel Norris Bequin welcomed the court's decision and urged the aggrieved parties to resolve the issue amicably and not resort to the courts.
It's a big relief for us that this matter has been put to rest, so we can proceed and work. Actually, ask that if anyone, as the judge has actually directed, that if anyone has any issue, we should be able to sit down and talk about it peacefully. This is not a matter that we should be bringing to the court to drag the name of the university in the mud.
The court awarded a cost of 9,000 cedis against the applicants. Meanwhile, a staff of the university has also filed an interlocutory application on a similar account against the reappointment of the Vice-Chancellor of KNUST, and this is yet to be heard. From here at the High Court in Kumasi, my name is Emmanuel Bright.
Well, a private legal practitioner, Justice Abdulai, is challenging the constitutionality of the office of Deputy Inspector General of Police in charge of operations. As you may recall, President Akufo-Addo recently appointed Commissioner of Police COP Yohuno as the Deputy IGP in charge of operations. However, in a writ dated July 30, Mr. Abdulai indicated that the appointment of COP Yohuno is, quote, unconstitutional, unquote. He wants the Supreme Court to nullify his appointment to the said office. Now, let's share with you details of this writ. It says, the nature of the relief sought by the plaintiff are as follows. 1, a declaration that on a true and proper interpretation of Articles 2021, 2022, 2023 of the 1992 Constitution, Section 3 of the Police Service Act 1970, that's Act 350, and Regulations 261, 62, 63, and 64 of the Police Service Regulations 2012, that's CI 76, the creation of the Office of Deputy Inspector General of Police in charge of operations by the President of the Republic is unconstitutional, null, and void. It again says, now the 2 is a further declaration that on a true and proper interpretation of Articles 2021, 2022, 2023 of the 92 Constitution, Section 3 of the Police Service Act 1970, Act 350, and Regulations 61, 62, 63, and 64 of the Police Service Regulations 2012, CI 76, the appointment of Commissioner of Police, COP, Mr. Christian Tete Yohuno, as Deputy Inspector General of Police in charge of operations by the President of the Republic of Ghana is unconstitutional, null, and void. 3, an order restraining Commissioner of Police, COP, Mr. Christian Tete Yohuno, from acting or purporting to act as Deputy Inspector General of the Police in charge of operations. 4, a further order restraining the Inspector General of Police or any command under him from accepting, relating to, and or issuing instructions or commands to COP Mr. Christian Tete Yohuno in his assumed capacity as Deputy Inspector General of Police in charge of operations. Now, 5, order 5 is any further reliefs, orders, or directions as this honorable court may deem just and proper. So that is the 5th order that Abdulai is looking for. So Justice Abdulai himself is joining us live on Zoom now. Abdulai, I'm grateful to you for joining. Now, you seek a declaration that, quote, the creation of the Office of Deputy Inspector General of Police in charge of operations by the President is unconstitutional, unquote. What specific aspect of the 92 Constitution do you believe are being violated by this appointment?
If you read the Constitution and how it creates the entire police service, it names an IGP. The Constitution doesn't name any other office. But of course, it allows Parliament to create other details of the police service. Now, in that enabling act, the police service then created additional offices, which includes, in addition to the office of the IGP, commissioners and other regional organizations and some of the skeletal organizations that we all know to be the police service. There is no way in the Constitution that allows for the creation of a deputy IGP, not in the Police Service Act either. However, a CI was made, and when I talk about CI emanates from.
I'm listening to you, sir.
I don't know whether you can hear me.
I can hear you clearly.
That you are off air.
I can hear you clearly, Justice. Justice Abdulai, I can hear you clearly. So well, we are still here with lawyer Justice Abdulai. He has petitioned the court to interpret what the Constitution really means and declare that the appointment by President of COP Yohuno as Deputy IGP in charge of operations is null, void, and unconstitutional. So we are speaking to him to really understand, because other people argue that this isn't the first time a Deputy IGP is being appointed. But again, the lawyers will explain to you that if you did that in the past and it was wrong, it doesn't mean that it is right if you do it today. So we are with him. He sent this writ to the court. We'll bring him back so we can have this conversation again to really understand what the Constitution says about the appointment of the IGP, and even only if, there is also a provision of appointment of the deputy IGP. And again, we want to find out which provisions of the Constitution at all is the president infringing on with this appointment. But we'll take a quick break just before the Energy Commission. The Ministry of Energy presents the 5th edition of the Energy Commission Senior High Schools Renewable Energy Challenge. This challenge aims to develop the research skills of senior high school students and promote technological innovation in renewable energy. We have that now. The competing schools for the northern sector are Ola Girls SHS and James Seminary SHS and Kranza Technical Institute, Wa SHS, Ndeura Jakpa SHS, Dakpokpa Technical Institute, Notre Dame Seminary SHS, and Walewale SHTS. The competing schools for the southern sector are Ahantaman Girls SHLs, and again, that's the school, Ahantaman Girls SHS, Infantsman School, Wesley Grammar SHS, St. Rose's SHS, Pando SHS, Ura SHS, Obuasi SHTS, and Wale SHTS. Join us for the Northern Zonal Challenge on Saturday, 10th August 2024 at 12 p.m. live here on the Joy News channel. It will be happening at the Engineering Auditorium, KNUST Kumasi, and at the Great Hall on Monday, 12 August 2024 at 10 a.m. for the Southern Zonal Challenge. This event is proudly supported by GIZ, Ashesi University, and VRA. Media partners is your one and only Joy News. Okay, let me go back on Zoom and bring in Justice Abdulai again. So, Justice, you were trying to explain that there was a CI that brought in the conversation, and then your line dropped there. What were you trying to put across there?
The Commission, Parliament, the powers the Parliament to possess, how they use the powers, and who should interfere, who should not interfere. So you have to make the difference between the executive and Parliament. That is how you are going to do it. You are building it with this law.
Justice, your line isn't.
This law that demonstrates the separation of powers. Okay. You know that's any principle. Before you come to the main body to argue why the president should not interfere at all.
Justice, if you can hear me, if you can reposition yourself a bit for us, we'll be grateful. In the meantime, though, let's take a quick break to fix this challenge. We'll be back with him to really get the education on this particular matter. Don't go away, please. Do stay. Welcome back. Let's return to our story about lawyer Justice Abdulai petitioning the court to interpret the Constitution into the appointment of a deputy IGP by the President, Nana Danko Akufo-Addo. Justice Abdulai is back with me again via Zoom. Justice, so great to have you back. The line wasn't really helping us, but we really wanted to understand which portions of the law the President is infringing on with this appointment.
Exactly where I was going to. So as I was saying earlier, there is no creation of a deputy IG in the Constitution. Neither is there any such position in the Police Service Act. But a CI rather created that office, but created a deputy IG simpliciter.
Okay.
It did not create any deputy IG in charge of operations.
Okay.
Now, the moment you import into the law what does not exist, you create problems. Which is why we are calling on the Supreme Court to nullify the appointment as made. If the President chooses to appoint COP Yohuno as a deputy IG, I think that we can accept it on the basis of the CI that created it.
But according to the CI, what responsibility should be given to the deputy IG?
In fact, a whole bunch of responsibilities.
Okay.
Literally everything. In fact, he's literally not even different from the IG, except that the IG is his superior.
Okay.
He is a deputy, and he's a single deputy. It's the deputy IGP. not one of several IGPs.
Okay.
Because what the president has done,
but just before we get there,
gives room for several other deputies to be appointed.
Okay.
Which is not known.
But just as you said, the CI gave several responsibilities to the deputy IGP, right? You made that point.
Absolutely.
Good. Now, is that, or are those duties different from the operations that the president has given? And if they are, in which form?
Okay, so this is it. What you are missing functions with an office.
Okay.
The deputy IG is an office, a creator of a subsidiary legislation.
Okay.
So now, if you understand ourselves from up to that point,
okay,
what the president has done is rather appoint a deputy IG, this time specifically, not with a particular function, just a particular function, but also for a particular portfolio, literally creating an office that doesn't exist.
Okay.
This is what the president has done.
Okay.
Creating an office that doesn't exist. It is irrespective which functions he performs, but that office doesn't literally exist within the Constitution and indeed within the Police Service Act, and even within the CI that created it. It didn't create a deputy IG in charge of operations. It simply created a deputy IG. Okay. And so if you import into it the functions performed or to be performed as a basis or as the name, the nomenclature for that office, then you'll be misleading yourself, and then you'll be creating the room, as I said earlier, for other deputies to be appointed. In which case, you may tomorrow have a deputy IG in charge of finance, a deputy IG in charge of administration, a deputy IG in charge of something. But all these are functions of a single deputy IG, simply seated under the CI. Okay. Assuming we are to accept that the CI is capable of creating that huge office, which was not created by the statute or created by the Constitution itself.
So in your view, if tomorrow the president says, well, he is deputy IG without operations, whatever, it is right?
Absolutely. I think that solves the problem, at least limitedly within the scheme of the CI that created that office.
But so what does that change? Because we have all agreed
everything.
We have all agreed that there are some functions that the deputy IG should perform. The president, in his own wisdom, feels that if you give him a specific duty, that, look, you are not a jack of all trades. Yours is to ensure that you manage the operations of the security setup or of the police service. I mean, isn't that what will bring out efficiency?
Assuming what you were saying is an ideal situation, there wouldn't be a problem with that. However, the moment that becomes the ideal situation, what the president needs to do is to go to Parliament where this law was made. Parliament, all of us put together, literally, stated and established an office called the Deputy IG. We gave him all the functions stated under the law. So if the president is not comfortable with that and thinks that maybe creating another deputy IG and giving him a specific function would inure to our collective benefit, fantastic. But you cannot do it by yourself. You go to Parliament and get that done. The president is not a lawmaker in this space. The president is an executive president who is in charge of implementing the laws that have been made. So if he's not comfortable with what Parliament has done, what he needs to do is to go back to Parliament. That, you know what, you guys created a deputy IG. I think the deputy IG you created over the years has not probably helped us in the way that I think it ought to. And so I need more deputy IGs so that each deputy IG can focus on a specific function. For me, as a president, I believe this is what would help in the security of the nation. You wouldn't have any problem with that. But you do not sit in your bedroom and create an office that doesn't exist in law.
Well,
you can't do that.
Not sure the president. Not sure the president sat in his bedroom anyway.
I mean, that is just on the side. But the point is that you have to follow the law in doing your activities, notwithstanding your private views and expectations of how things ought to be done.
Okay.
Follow due process, follow the law, get us to the right track, and then we are all good to go.
All right. So where are you in terms of this, petition or this writ that you filed?
Well, now that we have filed a writ, it has a maturity date of about 14 days, after which we are supposed to file statements. And after that, the AG would have another week or two to also respond.
Okay.
And then we go back to court. We go to court for the court to order us to file our memorandum of issues. And once the memorandum of issues are agreed upon and filed, then the Supreme Court would adjourn it for either arguments, for hearing, and then possible date for judgment.
Okay. So does this writ of yours mean that things revert to how they were, that there wasn't no deputy IGP, or he still keeps to perform his duties until the court makes the determination?
Indeed, until the court makes a determination, he remains who he is, and he can perform his functions, albeit we have filed in our application, there is a potential injunction on that office. But I do not think that my interest is really to bring a contempt action or otherwise. My interest is the ultimate decision that will be made by the court. And if the court, upon hearing the suit, comes to that conclusion, and indeed we've made a good case, and so he has to be either a substantive IG and not necessarily with all the other additions that were added, and for which reason he cannot exercise the functions specifically assigned that particular portfolio that was created for him. I think that will become the new norm, and we would all have to abide by that.
Okay. But they used to say the law is made for humans, not humans for the law. So if the law allows the appointment of a deputy IG assigned to several duties, and we say, okay, handle operations, once the law is made for us, can't we accept it and probably work with it to see how it leads to bringing about efficiency in the police service?
That would definitely lead us into chaos.
Okay.
It's without having to change the law. Okay. We all lead ourselves into chaos, because then in that case, tomorrow, if you also do something wrong, because the law was made for human, and you did something wrong, because somebody stole to feed his family, the law was made for human beings. And so we should allow that person to feed his family. Why would we have to imprison that person?
Okay.
Right. I mean, we should possibly amend the law to allow when you steal to feed your family.
Aren't you comparing apples with mangoes in this instance? Armed robbery.
I'm actually comparing apples with apples to the extent that we are talking about breaking the law.
Okay.
The object of breaking the law is immaterial so long as the law has been breached. This is the point I'm driving home.
Okay. All right.
Whether you breach the law to satisfy a particular society or you breach the law for a good reason is not part of the considerations of the law.
Okay. Now, back to the question.
That's as simple as that.
Back to the question about injunction. You said that in your rate has some element of injunction there. I understand that once an injunction is filed,
absolutely, then
all processes revert to their previous statuses. Isn't that the case? If it is so, then you expect that COP Yohuno won't hold himself out as a deputy IGP in charge of operations. Not so?
Actually, if an injunction is filed, let me correct that part. It is rather the status quo that remains. It's the status quo that remains. And so, and the status quo today is that COP Yohuno is deputy IGP in charge of operations. Until the Supreme Court decides otherwise, he remains in that office for good or bad reason.
Okay, interesting. All right, so let's see how this case progresses, and we'll all keep an eye out for what happens. Grateful for joining us, Justice.
Absolutely, absolutely, absolutely.
Lawyer Justice Abdulai is a private legal practitioner. He has filed a writ challenging the appointment of COP Yohuno as deputy IGP in charge of operations. He says his bone of contention is with that particular office Deputy IGP in charge of operations. We'll see how this case progresses. This is the pause. We'll take a quick break here. We'll be back with more. Please do stay.